I appear in this matter for the appellants with my own friends, Mr. Copeland and Ms. Hart, and Mr. Speck, Mr. Ward, and Mr. Gamza are here for the respondents. Before I begin, as you know, you have in front of you my appeal, which includes an application to amend the notice of appeal. Given the limited time we have, I was going to propose, subject to you, that I simply take that appeal point in the course of my submission.
Yes.
And then you can rule formally as to whether it's permission to be granted or not.
Yes. Mr. Purvis, thank you. That was the view we'd come to.
I'm most grateful.
Yes. Can I just say, as we're dealing with procedural matters, the 12th respondent has written to the court. They are not appearing today and will abide by any ruling of the court.
Oh, I'm most grateful. Thank you.
I would like all to know that we have carefully read the extensive judgment. We have carefully read the skeleton arguments, which have been of real assistance to the court. We note that in the authorities bundle there is just one authority. I have to confess, a first for me. And therefore, we will proceed on the basis that there isn't going to be a great deal of dissension on issues of law. We are conscious, as clearly you are, of the constraints of time today, and we assume you have spoken amongst yourselves as to how you're going to work out timings.
We haven't formally. I think my learned friend and I have been against each other often enough to understand each other on these matters. I was going to propose to open until approximately 1:45, which would give my learned friend equal time before lunch and in the afternoon, and then I would have a short time for reply.
Acceptable? Yes? Thank you very much indeed. Right.
I'm most grateful. And I'm very grateful for your indication of your careful reading of the judgment.
And we have been assisted by the skeleton arguments. Thank you very much.
I will give some introduction, if I may, to the background of the case, the issues, because it falls sensibly as part of my submissions to look at the background of common general knowledge as far as was agreed or found by the judge, then to look at the prior art in that context, and then to turn to the nature of the issues on the appeal and the judgment. So I think we should be fine within the time available to do that. The appeal, as you're aware, concerns a Bayer patent for the treatment of thromboembolic disorders by a compound which is known as Rivaroxaban. Rivaroxaban was developed and marketed by Bayer under the trade name Xarelto, and is one of a number of drugs that targets the biochemical processes that cause blood clotting and result in the creation of clots known as thrombi. The interacting processes which cause that you have seen from the judgment depicted as what's called the coagulation cascade, which you can see in paragraph 12 of the judgment. Nothing will turn, I don't think, particularly on the details of the cascade and how the various enzymes interact, although I may occasionally refer to direct and indirect effect of the targeting of various of those enzymes. But there is no dispute technically as to how all this works in the body. You'll see in the middle of that cascade factor 10A, which of course is the enzyme which is targeted by the drug in this case. Clotting is obviously a useful process in assisting the healing of part of the body from an injury. But excessive production of thrombi resulting in their release into the bloodstream can cause dangerous conditions known as thromboembolisms, and those can be particularly associated, as the judge notes, with the recovery from major surgery. And as at the priority date of, in this case, which is January 2005, that is to say, that's the date at which all questions of obviousness have to be assessed, there were various drugs seeking to suppress parts of the cascade or have some direct or indirect effect on the coagulation cascade. And in particular, the central feature you can see in that cascade, factor 10A, either directly or indirectly. And those were either already known and on the market or in development at the priority date. One of the major issues, naturally, with these drugs is, of course, the potential downside of reducing clotting in the body. Of course, it's a natural process which is there for beneficial purposes. And in particular, if you reduce the risk of clotting, fairly obviously you will increase the risk of bleeding. And that issue was known and is summarised well by the judge between paragraphs 17 and 18. If you've got that in the core bundle at tab 3, he summarises it essentially in the first two sentences of paragraph 17. Important feature of anticoagulant drugs is that if they're not sufficiently effective, clots will remain and new clots may form. If they're too effective, clots required at the site of injury will not form, particularly after surgery, and the patient will suffer excessive bleeding. Both possibilities are dangerous for the patient, and either may be fatal. At the priority date, the most commonly used treatment for thromboembolic disorders was probably warfarin. Its action on the cascade is in fact quite indirect. It inhibits a liver enzyme which impacts on the coagulation cascade. But a number of more direct acting drugs, including those which were directly targeted at the inhibition of the factor 10A enzyme itself, were in development at the date. And of course one of those was Bayer's candidate drug, Rivaroxaban. The patent arises from the results of...
Just on that,
yes.
It doesn't matter at all, but I'm afraid to say I can't resist my curiosity. The judge doesn't include apixaban in his list. Is there some explanation for that?
I can only assume that that wasn't around or known at the priority date, otherwise it would obviously
Came
be
later.
mentioned.
We think it's later or not.
Yes.
Okay, thank you.
I wasn't present at the trial, as you'll know, so it may be others will have to intervene on points of that kind. I was also a little surprised, given its prevalence in the market now. The patent arises from the results of phase 2 trials, and I'll come back shortly to what those involve, carried out by Bayer on Rivaroxaban. And the judge deals with the patent and the technical advance disclosed in the patent from paragraph 36 of the judgment. And it will be enough, I think, for me to take the judgment on the patent rather than to turn to the actual document itself. And in paragraph 36, you will see he cites two particular paragraphs, which are the passages that set out the technical advance on which the claims are founded. First, paragraph 9, which is a reference to the benefits of oral application as the preferable route of administration, and a less frequent dose regimen is desirable, and in particular once daily oral application is preferred due to favourable convenience for the patient and compliance reasons. However, this goal is sometimes difficult to achieve, depending on the specific behaviour the properties of the drug substance, especially its plasma concentration half-life. And then paragraph 12, the statement of the advance that's been made. Surprisingly, it's now been found in patients that frequent medication, that once daily oral administration of a direct factor Xa inhibitor with a plasma concentration half-life of 10 hours or less demonstrated efficacy when compared to standard therapy. The comparisons there were with another drug called enoxaparin, and at the same time was as effective as after twice daily BID administration. You'll see in the various points in the documentation in this case use of the letters OD and BID, which mean once daily and twice daily, respectively. You will note here that in both these paragraphs, the patent refers to the concept of a half-life and notes the difficulties in achieving single daily dosage depending on the half-life. Not surprisingly, at the most basic level, if the drug that you are administering to the patient disappears rapidly from the blood, and the half-life tells you at what point the concentration has dropped to half, you need to top it up to avoid cycling into a condition where the patient is unprotected. And in the most general terms, therefore, a short half-life is generally inconsistent with a long-acting drug. We'll come back to this question of half-life and the judge's findings on it in a bit more detail later. And it's the discovery in paragraph 12 of a surprising result from the trial, which forms the basis for the claimed invention. There is a reference there to the plasma concentration half-life time and how it's surprising that with that half-life you get a once daily oral administration which is as effective as twice daily. I should add in parenthesis at this point that in fact, as we shall see on the prior art, the best evidence of half-life at the priority date was considerably less even than 10 hours, down to something, say, between 3 and 5 hours. So on that basis, it could be said the result was even more surprising. I should say in the respondent skeleton, you will have noted some points made about the half-life of Rivaroxaban being shown by later data to vary between adults, depending on their age. But of course, that wasn't part of the common general knowledge at the priority date, and we don't see how it fits into any of the issues in the case before you. So in any event, put simply, the technical advance, which is the foundation of the patent, is the unexpected discovery that the results of a single dose once a day were just as good as a twice a day dosage. And the judge summarises the technical basis for that discovery by the patentee between paragraphs 38 and 41 by reference to the tables which are set out in the patent. And you'll see that the dosages which are applied in the experiments which are reported in these tables are 3 sets of twice daily dosages. If you look across the top, 2.5 BID, 5 BID, 10 BID, and then 30 once daily. I'm not going to spend time on the detail of the data in the tables. It's not in dispute that the patent did indeed demonstrate the technical effectiveness of a once daily dosage, at least to justify taking phase 3 trials forward, which of course would be necessary before.
I don't think it matters at all, but I should have remarked that, of course, there were 5 twice daily doses, including notably 30 milligrams. So in the phase 2 trial, you had both 30 milligrams once daily and 30 milligrams twice daily.
That's correct.
Sorry, you were saying.
I'm sorry. Yes. The dosage regime, of course, went on to prove successful with patients in phase 3 trials after this and in actual treatment since, as no doubt indicated by the great amount of interest from the generic companies in revoking this patent. The claims which were made off the back of these results to the once daily dosage regimes are set out in paragraph 42, and they are those of the court who aren't so familiar with patent claims, particularly in pharmaceutical cases, will find them rather convoluted. But they're the so-called Swiss form claims, written in this way to relate to the manufacture of a medicament as opposed to the treatment itself, but indirectly monopolizing the form of treatment via the intention of the manufacturer. These are the type of claims which are were until they became superseded by rather simpler claims, the norm for inventions in which a new form of treatment of an existing drug had been discovered. So the Swiss form claims are directed to the dosage regime itself, that is to say the use in rapid release tablet form administered no more than once daily for at least 5 days. Another feature of the claim, you'll see, includes a reference to the actual half-life of 10 hours or less in plasma concentration. But this feature was conceded by the respondents before the trial to be a non-limiting feature of the claim. In other words, it didn't feature
You say conceded, I rather think it was contended by the respondents and you conceded it.
Well, I'm not in
but
a
it was
position,
common ground, didn't
yes, I'm not in a position to give any evidence about why or how it happened, but it's common ground that it needn't concern the court.
Yeah.
Is, I think, all that matters for today's purposes. And indeed, for today's purposes, we're not interested in the rapid release part of that. The judge made certain findings about that which are not appealed. But we are concerned essentially only with the once daily feature of the claim, which gives it, we say, its inventive character. The underlying patent protection for the compound itself, that is to say Rivaroxaban, of course existed in parallel for many years with this patent, but predated it. That was extended by a supplementary certificate, patent certificate, but expired on the 1st of April this year. The patent in suit has another 19 months or so to run. The respondents are a number of generic companies, as you've seen, who intend to sell generic versions of Rivaroxaban to be used in accordance with the dosage regime of the patent, and they brought the action as claimants to revoke the patent on the ground of obviousness over certain prior art citations that I'll come to, and various other grounds that were in fact rejected. They are presently bound by interim injunctive relief not to put their generic drugs on the market pending this appeal. With that, I want to turn briefly to the prior art, but I'll come to that in a little bit more detail afterwards, but I'll introduce it at this stage. It comprises some so-called posters which were used to present the results of some phase 1 trials on Rivaroxaban, which had been carried out by or in conjunction with Bayer itself. A poster is the name given to a paper in summary form, which is displayed to the industry and the scientific community at conferences. And this case on obviousness was primarily advanced on the basis of the poster, which we refer to as Harder, presented by Sebastian Harder of the Institute of Clinical Pharmacology, the University of Frankfurt, and various others, including employees of Bayer. For your note, that's, as you know already, I'm sure, supplementary bundle 3A, where we've blown it up because the original version is quite hard to read.
Thank you very much.
And this publication or poster, the judge held, would have been read by the skilled team with two other posters referred to in Harder.
Well, they were all presented at the same meeting,
They were.
weren't they?
So they are jointly, those other two posters I'm going to refer to jointly as the Kabit posters, as the judge does, and they were all available, in fact, at the same conference, as you rightly say, in San Diego.
And that was 2003.
Yeah. And enlarged versions of those are at 4A and 5A, where we've done the same thing. The judge summarises that, for your note, at 72 to 3. We'll note when we come to it that the posters don't refer to Rivaroxaban by name. They use Bayer's internal code, which was BAY 597939. But it was established at trial that this would have been discovered by the reader to be Rivaroxaban, and that the chemical formulation was publicly available at that stage. So that particular issue has fallen away. I think it might be useful at this stage to consider the differences between phase 1 trials, which are the subject of the prior art, and phase 2 trials, which were the basis for the patent. The judge gives a good account of phase 1 trials at paragraph 24 of the judgment, or rather from paragraph 24. And as he points out, they're carried out on usually a small number of healthy individual volunteers. For some reason, invariably young, healthy males at this stage, I don't know why. But the intention is to pick up red flags for safety or toxicity. Obviously, those flags are somewhat limited in scope because the drug at this stage is not being tested on the vulnerable cohort of people for whom the drug is ultimately intended.
That comes in phase 2.
That comes in phase 2. And in particular, one wouldn't expect these patients to be at particular risk of thromboembolism if the drugs don't work, unlike the vulnerable cohort used for phase 2. Phase 1 trials give information on what's referred to as PK and PD, and you'll have noted, I think already, PK is pharmacokinetics. And that is the study of the impact of the body on the drug, essentially how the body breaks down the drug. And PD is pharmacodynamics, which tells you about the impact of the drug on functions which are carried out in the body. And what happens in these phase 1 trials is you administer the drug on a single ascending dose, SAD, or a multiple ascending dose, MAD. I.e., what happens is you give one or multiple drugs to one cohort of patients, then you increase the dosage for the next cohort, and so forth. Blood tests are taken from the volunteers, and assays which seek to measure the PK and PD effects are carried out in vitro on the blood that's been taken. And the judge summarises all that between 25 and 28. And you'll note at 25 that he points out that the key PK measurement is the half-life of the drug. I've already mentioned that in the context of the patent. It's useful in terms of potential dosage regimes, which are one of the things that you're going to have to choose for your phase 2 trial, because it indicates, at least as a starting point, the time between dosages if you're seeking to apply no more than a therapeutically effective dose each time. So by the time the dose has reached its half-life, the principle is you should repeat the dose. That is dealt with in some detail in the judgment. We'll come to that again a little later, but it's at paragraph 163. The pharmacodynamic studies, on the other hand, throw light on the length of time that the drug remains effective in the body by measuring the biochemical impact in the blood in the assays. Here, of course, the drug is intended to act as an anticoagulant and to suppress factor 10A. Factor 10A suppression can be measured directly or indirectly. So you can look at its effect on the production of thrombin, which is the next enzyme down in the cascade, which will give you a picture of potentially its effect on factor 10A. Or you can try and measure the factor 10A inhibition itself. There are a series of assays available to do that that the judge sets out from paragraph 31. In this respect, paragraph 27 is potentially significant. As the judge says, there may or may not be a correlation between the half-life of a drug and any one or more PD measurements. Thus, the level recorded from the biomarker assay may not decline by half at the same time that the drug concentration has reached its half-life. To a greater or lesser extent, PD data may follow a curve different to the PK curve. Obviously that, as we'll see, may have an impact on your assessment of dosage. If you're finding that, in fact, you're going down to half concentration, but the pharmacodynamic effect is still just as good as it was at the beginning, first of all, you might flag that as a rather odd result, or you might think, actually, I don't need to worry too much about half-life. In fact, as we'll see, in this case, such a correlation between half-life and PD effects was reported in the prior art to be the case with RIV. So there was support from the PD trials for the use of half-life. But we'll come back again to that in a little more detail later. Phase 2 trials are introduced by the judge at 29, and in essence we've got a larger cohort of volunteer patients who are, in this case, actually at risk and represent the targets of the treatment. Now, in a case like this, by definition, these patients may otherwise have been on a drug which is already known to be effective. So they may have been on warfarin, or they would have been put on warfarin. And therefore, they are vulnerable if the drug that you're testing proves to be ineffective, because they are potentially subject to the condition against which they would otherwise have been effectively treated. So that is a particular concern in this area, as well as the vulnerability of the vulnerable cohort to any possible side effects or toxicity. And one of the main decisions, if not the main decision that has to be made for a phase 2 trial is the dosage regime, or potentially a range of different dosage regimes which should be tested. And that decision would be made having reviewed whatever data is available, including the phase 1 trials, and a decision would have to be taken by the drug company seeking to develop the drug. And the dispute in this case, ultimately, as you'll see, came down to what would have been the obvious approach for the notionally uninventive skilled team to take if they considered, on the basis of the phase 1 trials as summarised in Arnold and Kabit, that they had enough data to justify a phase 2 trial in the first place. And assuming that they thought they did, whether the dosage that they would apply to the volunteers in the phase 2 trials would involve a single daily dosage regime as opposed to or as well as a multiple daily one. I use the term obvious. Of course, I mean here obvious to the notionally uninventive skilled team from the prior art, if armed only with matters which are, in the language of this field, part of the common general knowledge. And I'm sure you'll already be aware the skilled team that the judge refers to here is the fictional notional addressee of the patent. We are envisaging a notional team of scientists with the necessary combined skill set to implement the invention, but excluding the kind of inventive insight or imagination which in real life would almost bound to be found in an actual team of such people. And the characteristics and the general approach of the fictional skilled team to the prior art are obviously matters of great interest when making the assessment of obviousness. And I therefore propose to turn to what we say are the key findings of the judge in that respect, that is to say, the general approach of the skilled team to choosing a dosage for a phase 2 trial of an anticoagulant drug of this kind. And I'm going to submit that the judge makes 4 important general findings about the impact of the common general knowledge and the likely approach of the skilled team to dosage regimes which would apply to Rivaroxaban before I turn to look at the prior art and where that takes you. The first general finding I've put under the heading caution. We've already seen from the judgment that the fact that you're applying these drugs to a clinically vulnerable cohort of patients will obviously be a primary issue of concern to the skilled team. And I've given the reasons why. The judge repeats that on a number of occasions through the judgment, but one can see it in particular from paragraph 121, where he expresses the difficulties very clearly. The previous paragraphs deal with the concepts which I'm going to come back to of the therapeutic window. But he says in 121 the difficulty is quite marked in relation to an anticoagulant such as Rivaroxaban. Administering the new drug in a dosage that was too low posed a real risk of harm to patients in the study. Due to invasive surgery or for other reasons, they would be vulnerable to clot formation. formation. If such formation were not inhibited, or not sufficiently inhibited, a fatal thromboembolism in the brain or a lung or elsewhere could be the result. Equally, a high dose causing excessive anticoagulant activity could lead to bleeding, not just at the site of the wound, but elsewhere, such as the brain, again leading to harm and potentially the patient's death. Hypothetical team planning a phase 2 trial on the back of Bayer's phase 1 data would therefore have approached the trial with caution. If the team were to have considered trying a once daily dosing regimen, a reasonable expectation of success would have amounted to a reasonable expectation that wouldn't put the welfare of the patients in the phase 2 trial at unacceptable risk. I'm going to come back, if I may, to the concept of reasonable expectation. He also makes a similar point at paragraph 168. Where he's talking about the clinical and marketing desirability of, conceptually, of a once daily dosage. And you'll see from about 8 lines down, Professor Crowther, who was our witness, said that once daily administration is desirable. He wasn't sure, but it was highly desirable. Explained what he meant. It was never an end point in itself. Didn't override considerations of safety and efficiency. I accept Professor Crowther's evidence. The skilled team would have been aware of the clinical advantages. The team would have been part of a notional research department, not in academic isolation, fully aware of the potential financial advantages, but both considerations would have been secondary to safety concerns. And again, back at on to 211. The judge refers to the undisputed evidence. The skilled team would have it well in mind that the patients would be more vulnerable at both ends of the spectrum, more liable to bleeding if the drug level is too high, more likely to develop thromboembolism if it's too low. It's a reason why considerable caution is required when designing a phase 2 trial. Nothing was said in evidence gave the difference between the nature of patients any greater significance than this. The evidence from phase 1 is not predictive in the sense of giving certainty what will happen, in part because of the difference in condition of the patients, but of course, as he says, it provides important and necessary guidance. So the caution, or considerable caution, that would be applied is woven through the judgment. The second general consideration when selecting a dosage regime I put under the heading half-life. We've already seen the patentee's interest in half-life. And I explained
Although, of course, that would not be known to the skilled team at the priority date.
No. And I think when I looked at that, I said I would come back to the evidence and the judge's findings on the attitude to half-life at the priority date. Both the experts and the judge agreed that it was an important element in choosing dosage frequency, and specifically the half-life of the drug shown by the PK data in a phase 1 trial was held to be a starting point for the choice of a dosage regime. And that's discussed by the judge from paragraph 162. And you will see from this there's quite a bit of evidence at trial about the relationship between half-life and choosing a dosing regimen. Common ground between the experts that should be PK data showing half-life is a starting point for selecting a dosing regimen, and by implication for finding a regimen that will be safe and afford an effective antithrombotic effect. Information will be taken into account along with PD data. the claimants, the respondents, make the point it doesn't necessarily follow an appropriate regimen or require dosing at a frequency of once every half-life, as proposed by Bayer. I accept that. Evidence showed there were too many uncertainties regarding the effect of a new drug over time for there to be a universal rule of thumb across the board of dosing regimes for all known drugs. And then he refers to cross-examination of Professor Wilkins, who is the claimant's pharmacology expert, on how half-life data is used. And what's put to him is a couple of citations which refer to textbooks. The first is the definition of half-life, which everyone's agreed, time it takes for the plasma concentration to reduce by 50%. And then 5 lines up, question, when the drug substance is implied in no more than a therapeutically effective amount, which is usually preferred in order to minimise the exposure of the patient with that drug substance in order to avoid potential side effects. In other words, you're applying just enough, which is the usual safety first approach. The drug must be given approximately every half-life, citing Rowland and Tozer. You'd accept that's a true statement. I wouldn't accept it's a true statement. I think it's one of the factors. If we're just to dose on the basis of half-life, I think we get into trouble with a number of drugs, steroid ACE inhibitors, beta blockers. You would end up with overdosing. But I think it should say with that qualification, it is a starting point. It's a starting point. So the judge finds dosing every half-life not a universal guide. There are guides other than half-life, but half-life is an important contributory guide when beginning the search for a regime which is both safe and effective. That's consistent with what the authors of Rowland and Tozer, Clinical Pharmacokinetics, Concepts and Applications, 3rd edition, indicate. This is, as it were, a kind of rule of thumb, useful starting point. And this will become important again when we look at the prior art and what information you can draw there about PK and about the half-life. The third point I've put under the heading, the ribbon and the therapeutic window, which almost sounds like a good title for a historical novel. Perhaps wouldn't quite fly off the bookshelves. What's required as a matter of principle, ultimately, is a dosage regime which will keep patients safe across the period of treatment from the development of embolisms, but also avoid the excessive bleeding. And that requires a dosage regime with what's called a ribbon, which covers the maximum and minimum effects of the drug, remaining within the therapeutic window at all times during the period of treatment. So there are two things to think about here. First is the concept of the therapeutic window itself, and that's what the judge has dealt with in paragraphs 17 and 18 that we've looked at. The judge deals with the two possible dangers: not being sufficiently effective, so you'll get blood clots; being too effective, so you get excessive bleeding. Both are dangerous, and as the judge says, there is thus a therapeutic window in which the drug is available enough to have a sufficiently anticoagulant effect, but not so available and effective such that the patient suffers from unwanted bleeding. And he comes back to it at paragraph 120. This is in general terms. And he says there, despite the clues from phase 1 data, a team conducting phase 2 trials for the first time cannot know where the therapeutic window lies in relation to patients having the relevant condition, or whether the window is narrow or wide, nor can the team know what dosing regimens will result in the effect of the drug on patients falling within the therapeutic window. And I then want to just turn to the drawing which the judge puts in at paragraph 170 of the judgment, which is a graph from the defendant, the appellant's witness, Professor Maibaum, illustrating the concept in 169 that the skilled team conducting a phase 2 study with no knowledge of the size of the window, which the judge has already said would generally be the case, would aim for a relatively small peak to trough difference in the concentration of drug in the plasma. This would increase the chance of the ribbon falling safely within the window. The ribbon was the name given in argument to the wavy line graphically representing drug concentration in the plasma over time after steady state has been reached, oscillating between maxima and minima. And you can see that illustrated in the graph. The window which has been drawn there has an upper limit marked toxic. That's obviously the point at which, in this case, excessive bleeding would occur. And the bottom line headed sub-therapeutic, which is of some importance because, of course, it could well be that there is some activity, some measurable biochemical activity going on, but the key is whether it's therapeutically effective or not. And if it drops to a level where it is sub-therapeutic, then your patients are immediately in danger from thromboembolisms in this case. And what's going on in this particular drawing is that Professor Maibaum is illustrating the fact that we'll come to, that if you administer a low dose on a frequent basis, you have more of a chance of staying within the therapeutic window as a matter of principle than if you administer a high dose hoping to get through the whole 24-hour period, for example. So what is shown here is a triple administration every 24 hours, which is the red dotted line, as against a single administration every 24 hours, where 3 times the dose obviously has to be given at the outset. And of course, you may find, having done that, that you manage to stay within the therapeutic window if you're doing the blue line. But to do that, you probably have to give even more than has been done here, and you've strayed into the toxicity area. And of course, if you try and stay with your peak below the toxicity line, then you are liable to drop for substantial parts of the of the 24-hour period below the sub-therapeutic line, so your patient is in danger that way. But if you give relatively frequent small top-up doses, the idea is you can avoid both. And there was discussion in cross-examination of Professor Maibaum, and an alternative drawing was put to him, and the friends make some points about that in their skeleton. But ultimately, the judge makes findings as against which there's no respondent's notice in paragraph 176. And as the judge notes, it wasn't put to him there was anything inaccurate or misleading about his graph or the answers he gave in relation to it. And the answers he gave in relation to it confirmed his points that the skilled team contemplating a phase 2 trial with Rivaroxaban based on phase 1 data would know that administering a relatively low dose at relatively high frequency would result in a narrower ribbon and a better chance of staying safely inside the therapeutic window, wherever it turned out to be, because of course one doesn't know where it is at this stage. he was not challenged on that assertion, and I accept it. So there is a clear finding by the judge, we submit, that the ribbon and the therapeutic window are important considerations when designing a dosage regime, and that the skilled team would approach the dosage regime knowing that relatively high frequency, relatively low dose was the safe approach. And the fourth point I want to make concerns the information which, or lack of information, which the skilled team would have in this case as to the position and width of the therapeutic window in the case of Rivaroxaban, based on their common general knowledge or the phase 1 data. And the judge, as we've seen, made a basic finding about therapeutic windows at paragraph 18, which was that it was never possible to know in advance where the therapeutic window lies and how wide the window will turn out to be. Now, I think that probably needs to be finessed a little on the basis of other parts of the judgment, because the respondents attempted at trial to show that the skilled team would have particular knowledge about the therapeutic window likely to exist for Rivaroxaban, which would encourage you to think that it was wide and thus easier to keep the ribbon within it using a single dose regime. In particular, they said there was material from which the skilled team could conclude on the basis of their common general knowledge that the therapeutic limit, the lower line, was quite low in this case. And that was based on alleged knowledge by the skilled team of the behaviour of similar drugs already on the market or whose activity had already been published, from which they said you could take a better educated guess than normal and be therefore rather less cautious in terms of the dosage regime that you might need to adopt for your phase 2 trials. And we should look at that because the judge makes findings about that argument between paragraphs 165 and 167. And there are two things going on here. First, he raises the subject of LMWH. These are low molecular weight heparins, which were, he says, known to have a half-life ranging from 2 to 6 hours. The priority date, enoxaparin, you'll remember, is the comparator that was used in the patent. And LMWH was a known treatment of ETE. It's a factor Xa inhibitor, but it doesn't target factor Xa directly. Although LMWH was known to exhibit no measurable anticoagulant effect beyond 12 hours and sometimes administered twice daily, it was also part of the CGK at the priority date. They could also be effective in a once daily dose. There was disagreement, he says, regarding the extent to which the known anticoagulant effect of LMWHs would have provided a guide to the likely effect of Rivaroxaban and what this might mean for its therapeutic window. Professors Crowther and Hirsch were agreed that the mechanism of action differs from that of Rivaroxaban. Several potentially significant differences, including molecular structure, etc. Professor Hirsch believed predictive parallels between the behaviour of LMWHs and Rivaroxaban would have been drawn at the priority date, but he has a particularly high level of knowledge about LMWHs, didn't identify any documents which would lead to the conclusion that those expected parallels form part of the CGK. I find they did not, Professor Hirsch made a similar, though more reserved, point about heparin. Likewise, I felt that I find the skill team would have made no predictions based on heparin data because such data was not within CGK. And then in 167, some suggestion it was known at the priority date that other factor 10A inhibitors had a wide therapeutic window, so the same may have been expected of Rivaroxaban. Cross-examination, he said that this was based on material made available at the ASH conferences held a month before the priority date. I'm not satisfied that publication at the ASH conference led to the information becoming sufficiently widespread so as to attain the status of CGK. So there was certainly argument in the case, and Professor Hirsch certainly considered you could draw information from other factor 10A inhibitors, but unfortunately for the respondents, they lost on the fact, and it was not established that this formed, any of this formed part of the common general knowledge of the skilled team. Professor Hirsch was no doubt extremely well qualified, but he was in no way representative of the notion of skilled person. So the result was, it may be that in some cases you can draw parallels with other drugs and try and learn something from other data, but priority date in this case, there was in fact no knowledge so far as the actual skilled team is concerned, which would allow them to draw those conclusions or parallels, and therefore they would be entirely ignorant of what level of anticoagulant effect measurable in PD studies would be enough to give therapeutic protection, keeping the ribbon inside the lower line of the window, or indeed straying over the top of the window and causing excessive bleeding. I'll come back to that later when we look at the judge's ultimate conclusions, not least because the impact of these findings, of course, was that Professor Hirsch's actual opinion on the obviousness of an appropriate dosage regime was plainly and substantially coloured by material which the skilled person would not themselves have taken into account. So, to summarise, what we say can be deduced from the judgment as points of general principle as regards the common general knowledge and its application to a dosage regime for this kind of drug for phase 2. The general propositions are caution, half-life is a good starting point, multiple low dosage is the best approach to keeping a ribbon within the window, and there was no special knowledge as to where or how wide the window would be in this case, and therefore no reason to be particularly confident that any other dosage regime would be likely to hit it. And with that, I want to introduce the fundamental question, the legal issue that the judge resolved ultimately against my client. As I've said, it's whether it would have been obvious to the skilled person to adopt a once daily dosage regime at the priority date for phase 2 trials for Rivaroxaban on the basis of the information about the phase 1 studies, which can be found in Harder and Kabit combined with common general knowledge. I should just parenthetically introduce what the concept of obviousness means in the context of a decision to adopt a regime of this kind. Clearly, at the priority date, you can't just jump from phase 1 trials or even phase 2 trials right through to a drug that you are handing out to public. You will need to go through the phase 3 trial process. They are lengthy, complex things to carry out. The patent has, of course, only disclosed the results of phase 2 trials, hasn't got as far as phase 3 trials. And it's those results, the phase 2 trials, which are the technical contribution that the patentee has made. So what we mean in a case of this kind, when one asks the obviousness question, is whether it would be obvious to try the claimed dosage regime in a phase 2 trial. Was what the patentee did obvious to try, or has he made a non-obvious technical contribution by trying it and then finding the unexpected result? And those obvious to try cases come up regularly before the courts. And there's a danger which has been recognised of unfairness to patentees, particularly in the pharmaceutical field, if the phrase is adopted without further consideration. It's long established it requires more than the mere obviousness, for example, of conceiving of a treatment or a regime, or even contemplating the fact that it might work. Rather, it must have been obvious that there is a reasonable prospect of success if that treatment or that dosage regime is adopted. And it's that recognition which is the ultimate touchstone of whether something can be said to be obvious. And it's by that means that companies such as Bayer have invested a great deal to uncover the data that enables a drug or a dosage regime to be safely adopted to public benefit are properly rewarded for their efforts. Now, of course, if all they've uncovered is data that would simply reasonably have been expected from the knowledge that was already available, then there's no basis for a patent. But if they reveal something new that can't be described as an expected result, and thus enable something for the first time to be taken forward to phase 3 trials, then they have made a real contribution in terms of technical effect, which deserves protection and reward. And we've got no issue with the way the judge dealt with that question as a matter of law, and I think it's common ground. But the key issue is how did the judge find that there was or that there would have been recognised to be a real prospect of success with a once daily dosage here, and did he make errors of principle in coming to that conclusion? Before we turn to look in a bit more detail at the prior art, it may be worth stating Bayer's case when one looks at that prior art, which was a simple one. It was, given the potential dangers, first of all the potential dangers to the phase 2 volunteers, if you were on either side of a therapeutic window, given the watchword of caution, given the lack of knowledge from the common general knowledge of where or how wide the therapeutic window was, and given the preference for frequent dosages was more likely to hit the window, you would have had to find some convincing data in the prior art to establish that a once daily dosage would have a real prospect of being therapeutically effective over the 24-hour period and not stray outside the window in order to make the claim obvious. And Bayer's case is that the prior art provides no such data. Of course, it tells you nothing at all about therapeutic effects, and the evidence of any effect at all in terms of anticoagulants lasting as long as 24 hours was weak at best. What Bayer say you can draw from the prior art is it provides solid half-life information accepted to be the basic starting point, and that point's well away from one daily dosage, comes out at 3 to 5 hours or so. And Bayer say it certainly can't be said when one looks at these documents that once daily dosage had a reasonable prospect of success in a phase 2 trial. And with that, we need to look at what the prior art shows. I'm hoping not to have to take you too much to the prior art because the judge did a pretty good job of summarising it, but there may be the occasion where it might be more helpful to look at it. So the harder poster, which I'll first deal with, is at tab 3A of the SUP bundle. So it might be worth just having that to hand in case you need to look at it. The judge turns to it at paragraph 178 of the judgment. And quotes the introduction to harder in that paragraph. It's introduced, so Rivaroxaban, as we know now, is introduced as a selective highly-potent direct Patentee inhibitor being developed for the prevention and treatment of thromboembolic disease, shown to be well tolerated at single and multiple doses up to 30 milligrams, with a terminal half-life of 9 to 12 hours. We'll come back to that proposition. The aim of this study was to evaluate the effect on thrombin generation. So this is measuring Patentee inhibition indirectly by looking at thrombin, which is the next stage down in the coagulation cascade, in healthy male volunteers. And as you'll see in 179, this was carried out on only 12 healthy male subjects, and only 8 of them actually received the drug itself, 4 had a placebo. The 8 received a single 5 milligram on day 1 and a single 30 on day 14, sufficiently later the first dose had been expelled, or vice versa, and then they carried out assessments of thrombin generation, platelet-induced clotting over 24 hours, and the judge gives details of 3 assays, a PIT assay, an ETP assay, and a PICT assay. He's already dealt, I think, earlier in the judgment with what those assays were. I don't know exactly where that is. I think it's paragraph 31 or 32. Yeah. So ETP is endogenous thrombin potential, PICT is prothrombinase induced clotting time, and PIT is thrombin generation time. But over the page, the judge reproduces the graphs which are set out in harder. And what one sees here, you'll recall there was a 5 milligram and a 30 milligram dosage pending, and all volunteers took both, but at different times. And then there's a placebo. The placebo is the triangular markings on the line at the top. 5 milligrams is the red, and the black is the 30. And what one sees with this small number of participants are measurements taking place over 12 hours, so every 2 hours they do these assays. And then there's a single measurement after that taken at 24 hours. You'll see the bottom one, which is the ETP AUC tissue factor test. There is no, by the time you get to 24 hours, the impact seems to have gone down to nothing at all. In the other ones, you'll see the effectiveness falls away throughout the 12-hour period in each case, in various different ways. Then one has the 24-hour measurement, where it is diminished further, in some cases more dramatically than others. What you also see at the end of the lines there, you'll see those little cross markings on the vertical bar at the 24-hour, the line that marks the various 24-hour measurements. These are error bars enabling some view to be taken of the statistical significance of the measurements that are being taken, though it's unclear precisely what relates to what. Sorry, Leonard Friend rightly says gives you standard deviation. We'll come back to the error bars in a bit. The judge summarises those results. He refers to the 24-hour measurements in paragraph 185 as showing some residual activity. He's referring there to other plots found in figure 4, which is similar to the plots found in figure 3. But what needs to be noted, of course, is small number of participants and the error bars. And that may be why the actual statement about the results made in Harder, in each case, you'll see from 181, the quote at the end, 183 and 184, the effect measured in terms of inhibition of ETP peak in 181 is said to be sustained over 12 hours. No reference is made to the 24 hours. Similarly, in 183, increase in PIT, last sentence, sustained by the 30 milligram dose over 12 hours. And again, 184, PIT prolonged over 12 hours, the last sentence. So the body of the discussion of these results speaks only of the 12-hour sustained increase or effect of the measurements. If we go now to back to the judgment at 186, the judge quotes here a section from Harder that says, in agreement with other phase 1 data, the Kabit posters, Patentee inhibited dose dependently, was inhibited dose dependently after administration of Rivaroxaban. Maximum inhibition was observed at 2 hours, and then there's a reference to the details. Patentee inhibition correlated closely with ETP, as demonstrated by the values of the ETP peak. And then the poster covers various conclusions which are set out in bullet points, and the judge reproduces them at 187. So the first is dose-dependent inhibition of intrinsic and extrinsic pathways of thrombin generation. That, of course, is what they're measuring. Effect of Rivaroxaban on thrombin generation demonstrated in platelet-free assays and PRP-based assays. In contrast, indirect factor 10A inhibitors, those are the rivals, obviously only inhibit factor 10A that's not protected by the platelet prothrombinase complex. Don't need to worry too much about that. The next one not only inhibited the time lag of thrombin, but had a profound effect on the maximum effect of thrombin generation. Suggests an additional feature of Rivaroxaban because weaker factor 10 inhibitors may only prolong lag time, etc. And then 4, which is what we're going to have to come back to, and is the high point of the respondent's case. Some parameters, e.g. ETP peak, indicate a long-lasting PD effect of Rivaroxaban, which suggests suitability for a once-daily dosing regime. And then the final one talks about it being a promising anti-coagulant. So bullet point 4, we say tentative in its language compared to some of the other statements in the bullet point. And not surprising that it's tentative, given what we know about the approach to dosing regimes, and certainly no recommendation of trialling it. More importantly, in the end, the experts didn't place a lot of weight on Harder's data as actually giving any support for the idea of once daily dosage. In fact, even the respondents' experts in chief, the judge deals with this from paragraph 214 by reference to Harder itself. So he summarises the impact of these assays in 214, showing plots for up to 24 hours, suggesting in 3 out of 4 cases there was residual activity, although the last plots have error bars. Mybone thought that because the data was based on only 8 patients, the lack of plots between 12 and 24 hours, data was scientifically weak, consistent with the authors being prepared only to say that the effect was sustained over 12 hours. We've already seen that that was the actual impact of the paper, the poster itself, when discussing the results. Professor Crowther agreed, adding the overlapping error bars meant it wasn't possible to tell the degree to which there was an anticoagulant effect after 24 hours. Professor Hirsch accepted the authors hadn't said there was a sustained effect beyond 12 hours, but pointed out the 4th bullet point. Professor Wilkins expressed the view of the skill team were to dose at 12 and redose at 12. The ETP peak assay suggested thrombin would be inhibited for 24 hours. This wasn't clear. He may have meant climb to steady state thereafter dosing every 24 hours would prove sufficient, but wasn't asked to clarify. But then in 217 is the key. He says the balance of the expert's evidence was that only limited weight one way or the other could be attached to the Harder data if considered in isolation. We'll come on to that point. So on the basis of Harder alone, I can see how a case could properly have been made out.
But he wasn't taking it just on Harder alone, was
No,
he?
he wasn't. And that's where I'm coming to. So we move on to 218. And the judge takes the 4th bullet point in 218 that some parameters suggested a suitability for once daily dosing to have been made with the data from the Kabit posters also in mind, because they expressly stated, that's elsewhere in the paper, in the poster, that the factor 10A inhibition data was in agreement with the data in the Kabit posters. Harder and the Kabit posters have to be taken together. And then he turns to the expert's overall conclusion on Harder and the Kabit on the Kabit papers. Those are summarised from 188. Much larger cohorts of volunteers. You can see that from 189. So we have a SAD study that we've looked at and a MAD study. SAD study carried out on 103 healthy men under fasting conditions. Some received it in 9 steps, so they got successive doses of stepping up the dosages of those tablets up to 80. And then it was administered to others in oral solutions. Others received placebos. And 198 is similar. The MAD study was 64 subjects, of whom 61 also took part in PK analysis. Where we get to is the graph at 192, which is the results of a SAD study, which is in fact a direct measurement this time of factor 10A inhibition. Unfortunately, these graphs are quite hard to read and came out very blurred, and some of the experts seem to have struggled in trying to work out what was shown as exactly happening. But you can see here, over 24 hours, measurements are taken at...
to my eyes, the copy we've got in the supplemental bundle tab
is better.
4A, I think it is.
Yes.
Page 26 is a bit easier.
Yes, I think that's right. So it may be easier just to take it off that.
We're looking at page 25.
I think we're looking right at page
26, I think.
Is it?
You're on figure 1, are you?
Yeah, we're on figure 1, which I've got on 25.
Oh, sorry, I thought we were looking at figure 3. My apologies. Yes, figure 1. Thank you. That's 25.
Yeah. So one can see at these various dosages, not surprisingly, the higher the dosage, the bigger the inhibition effect. And they are measured what appears to be multiple times up to 4 hours. And then at 6, 8, 12, 13 and 24. And what essentially they all seem to show, certainly the more substantial dosages, is a fairly rapid fall off in terms of factor Xa inhibition to 12 hours, and then levelling out, falling away more gradually down to 24 hours. And the judge's finding of fact here, once again, is that there is some residual effect visible after 24 hours. But of course, what one's looking at here is simply an anticoagulant effect by inhibition of factor Xa. There is no knowledge of the extent to which, once you're down to that level, there is in fact any useful therapeutic effect, which follows from the judge's findings at 194. We say the only evidence that might have helped you work out whether this might still be useful would have been the kind of argument from similar drugs that Professor Hirsch had engaged in, such as the heparin reference or the other factor Xa inhibitors that he gave evidence about. But of course, that was not part of the common general knowledge. One is shooting in the dark so far as therapeutic value is concerned. The other thing the judge points out, back to the judgment, is from 195. He deals with the PK results, where he quotes the poster, and of course this time we've got actual data, and we've got a large number of subjects, plasma concentration time profiles, so rapid absorption and administration, maximal plasma concentration treated after 30 minutes, and the half-life was estimated to be 3 to 4 hours. Factor Xa inhibition plotted against plasma concentration, showing a close correlation at higher plasma concentrations. So we do have that link that the judge has already identified as important to the relevance of half-life, that there is a close correlation at higher plasma concentrations between factor Xa inhibition and plasma concentration.
So just checking I've understood this correctly. The half-life in harder is tablets. The half-life in Kabit, certainly here, is oral solution, not tablets.
It looks like that. Is that right? I think tablets would, one looks at 189, they seem to be receiving tablets in the SAD study. Then there were oral solutions as well.
But he says specifically in 195 that the half-life data is for the oral
Absolutely,
solution.
yes. So far as that's concerned, you're right. Yes. So that's the oral solution.
Now,
Within the other one.
Yeah. And the other one. Yeah. I think the other one, which is the MAD one, where they also looked at half-life, I'm told that was tablets.
where do we find
Where
that?
that is in the judgment or in the paper, someone will tell me.
Page 30.
Yeah. That looks like page 30 of the poster. Under treatment. 6-dose steps, Rivaroxaban or placebo tablets.
Column 5.
And
Column 5. Yeah, page 34, last column is the
oh yeah, so the half-life here is given on page 34, and I think the judge records it as well, as 5.8 hours or 3.7 hours. That's the top of page 34.
different doses, I think, if you look at 300.
Yeah. Yeah, I think the learned friend's right. The judge summarises this at paragraph
236 and 237. 236 and 237.
yeah, paragraph 200, and then at 236 and 237, yeah, there's more reference to it. But when we come to it, the judge finds doesn't seem to be making distinctions between the tablet or other forms of administration. He concludes ultimately that the skilled person would have regarded the Kabit half-life data as more reliable. So anyway, we have 3 to 4 hours and 3.7, 5.8 hours, all figures around those regions measured in the Kabit posters. Plus, as we say, the finding that inhibition is correlated with plasma concentration, which would validate the utility of the half-life as a good starting point for dosage. The judge's the conclusions that are made in the Kabit posters are set out at 202 of the judgment. And these are notable. First of all, it's said to be safe and well tolerated, inhibited factor 10A activity and dose-dependently affected PD parameters. And then the second bullet point, predictable dose-dependent pharmacodynamics and PK were demonstrated and indicated that Rivaroxaban is suitable for twice daily administration, up to 30 milligrams. And then we've got the close correlation and the good safety profile indicating further investigation is warranted. So, very short half-life, recommendation suitable for twice daily administration up to 30 milligrams. And we would say at that point things don't look terribly good for the obviousness case. Watchword of caution, frequent low dosages, as we know, are known to be the best to try and hit an unknown therapeutic window. Therapeutic window was in fact unknown. Harder suggestion of suitability for once daily, not actually considered by the witness to be something you can conclude from his own data, and his body of his own poster only noted effects over 12 hours. If you turn to Kabit, you find half-life, which is very low, 3.7, 5.8 hours. And those posters, of course, have the most reliable data statistically, but draw no attention to the so-called residual anticoagulant effect that the judge says may be visible at 24 hours, and only recommend twice daily dosing. And you might think that a cautious, unimaginative, skilled person without the special knowledge of Professor Hirsch, on the basis of these papers, would be unlikely to go for a single dose regime or think that it would have a realistic prospect of success in keeping the ribbon within the therapeutic window. The judge disagreed, and his reasoning starts at 248. And what one finds with the reasoning is that he starts with the awareness of the clinical advantages or financial potential of a once daily tablet, but says that would have been secondary to their safety concerns. But even if that wasn't at the forefront of thinking, where the prior art raised the possibility, that possibility would have been given serious consideration. And from that, he says, it follows the skilled team would have found the statement in Harder, some parameters, so this is the fourth bullet point, both striking and encouraging. The authors of Harder were either, like Dr. Harder himself, distinguished clinicians of apparently international renown, like Dr. Mr. senior figures in Bayer, very much a leader in the field. Skilled team would, in my view, consider carefully why these authors had been prepared to put their names to that statement. And there's a reference to the blood abstract saying something similar to Harder. And he says what the skilled team would have done was first of all consider the reported evidence in Harder itself, the reported evidence on half-life. So in 250, he reports the Harder number, supportive of the idea of once daily dosing, but then says, as Professors Crowther and Mybone pointed out, there was no PK data supported. The study only involved 8 participants. The number of volunteers in Kabit was much larger, and there was supporting data. The figures of 3.7 and 5.8 hours would have been seen as more reliable. So the judge is definitely approving the short half-life figures in Kabit here over the vague statement in Harder without evidence and off the back of what appears to be a very small cohort. So that doesn't look good so far. So what he does then, he says, oh, well, the authors of Harder must have had the data in the Kabit posters in mind. We've already looked at that.
Would you dispute that proposition, given that there's a significant degree of commonality in the authorship between the 3 publications?
Yeah, and there's no...
So they're unlikely to have put it out of their minds when writing Harder.
Yes. Yeah, I think that's a very fair point, and it's certainly not an issue that we take on this appeal. What we say is if you go to Kabit, you're actually being pointed in the opposite direction. Anyway. Harder refers to the data of the Kabit posters as being supported.
So can I just follow that up?
Yeah.
Because would you accept that it's implicit in the submission that you just made that the authors of Kabit, who were also authors of Harder, went on, having made the studies that they did in Kabit, to make a statement which they must have known was unsupportable?
Well, we don't know precisely what order things were done.
We know the posters were presented simultaneously
Yes,
with and
exactly.
alongside each other.
Exactly. And we don't know who was responsible for the statement in the Harder paper. I mean, there are differences in authors between the Harder and Kabit's papers.
To be sure,
We've
but
got
there's,
them
as
exactly
you've
in front
accepted,
of
there's
you.
a significant
There is
commonality.
some overlap, absolutely. So who was responsible for making what statement, we can't know. But it's notable that that statement wasn't made in Kabit itself, which talks about twice daily dosages. And one doesn't learn any more from Harder that would help. At least no valuable data seems to be given which would assist in coming to that conclusion.
So, do you have any submission to make as to why the court should consider that the authors of Harder made an unsupportable statement?
Yes, all the pointers, we say, objectively, on the documents themselves, would not have led the skilled team to conclude that a once daily dosage regime was something that would have a reasonable prospect.
I'm sorry, but that I'm not sure that's an answer to my question.
Sorry.
I mean, what your submission is, and I understand it legally, that your submission is unimpeachable, because what you're saying is, no matter what the reasons for making the statement were, the skilled team's reaction would be to be sceptical. And I understand that. That's a very clearly articulated and legally coherent submission. But what the judge is doing is he is asking himself, why would the skilled team think the statement was made in the first place? And do you say that's an illegitimate inquiry?
No. We would say...
Particularly given, as I say, there's a commonality of authorship.
Yeah. The evidence...
So the question remains, why on earth would one conclude that the Harder team, which included a lot of the same people as the Kabitsa team, made a statement which you say is unsupportable?
I think that covers quite a few different aspects of this case, if I can put it that way. I mean, there's the question of the status of the authors and whether any weight should be given to the authors or any assumption made about their ability to make a statement which the skilled person might themselves think is not really supported by the data. And one does find this in scientific publications a lot of the time. But if one doesn't know the precise skill set of the person who's made the observation and has nothing to go on other than the data which is in the paper itself, we say there's certainly no basis for assuming that it's made on using some other data. And if there's no basis for that, the only thing that a reader can do is assess the validity of the statement based on the data that's been presented. And that there was some cross-examination and evidence about this. And Professor Crowther, that was I think we've got it set out in some of the transcript references. Professor Crowther said, I wouldn't take statements like that at face value. I'd always go back and look at the data. So we submit the kind of, I don't mean, the slightly ad hominem approach, which says, well, this author said it, so it must have some implicit validity, isn't the correct approach to adopt. Yes, it might attract your interest, but if one's designing a phase 2 trial or contemplating a phase 2 trial, you're in a serious game. And all you can do is look at the data and draw your own conclusion.
Thank you.
But I'm going to come back, I think, at the end to what we say about the status of the authors generally. But I think it does raise a larger point about the value of statements of this kind. If, on a proper view, they're not really supported by the data. Just to finish off on the judgment, so the judge at 252 sorry, we've got to 250, haven't we? And we got to the half-life data. We get to 251 and the statement that must have had the data and Kabit supposed to in mind, and we don't dispute that because of the commonality of authors and the reference to Kabit, so they clearly were aware of the work that was being done, as it were, in parallel. Harder refers to the data of the Kabit supposed as being supportive as at least of some of the PD data, and the authors probably would not have pointed out that some data supported was that if such data were to be dismissed as no valid. I'll come back to the status of the author's point, because of course by this stage the judge has already inflated the status of the authors in the way in which we complain in our amended grounds of appeal. 252, he then says, so the skilled team would therefore have turned to the PD data. So now we're looking at PD. We've got a statement in Harder about the ETP results showing inhibitory effects sustained over 12 hours. Hirsch says graphical evidence gave some limited support for sustained anticoagulant over 24, though the authors haven't seen fit to state this, and the error bars meant the evidence may not have had statistical significance. So we don't seem to get very far, and that equiparates with what the judge has already said about the significance of the Harder data. Larger and more reliable studies into Kabit posters suggested in their graphs that anticoagulant effect significantly sustained 24 hours after administration. We've seen those graphs. I think elsewhere he calls it residual. On the other hand, these posters also concluded that anticoagulant activity, according to PD assay, closely correlated to plasma concentrations. So we're back to the half-life correlating to anticoagulant activity. Apparent contradiction seen as such was not directly confronted. And he notes that at a low plasma concentration there isn't a close correlation. It may be that at low plasma levels, expected 24 hours, anticoagulant activity would no longer be expected to correlate. Detail of graphs wasn't addressed. As against that, and this is really the only conclusory point the judge makes, it was resolved in the evidence of Hirsch and Wilkins and conceded by Mybone that SAD shows graphical evidence of anticoagulant activity 24 hours after administration, including 24 hours after administration of a 30 milligram dose. And we've seen in the graph, one can see that. But, of course, the question remains, as the judge will say, what does that tell you about the therapeutic window and the therapeutic benefit of anticoagulant activity at that low level? Taking all the evidence together, I think the skill team would have believed it was reasonable for the authors of Harder to say that there was data in Harder and Kabitzer that suggested it was suitable for orally administered once daily. That left the question whether the data indicated there was a dose that would be both safe and effective. I'm not entirely sure where that paragraph goes, because the second sentence seems to kind of contradict the first. But he seems to have essentially held that there was data that made it suitable, but then contrasted that with a dose that would be both safe and effective. So whether by suitable he means, I don't know what he means. We struggle with that paragraph. Anyway, he goes on in 255 to deal with safe and effective. And he talks at the beginning about wide tolerance, so you can give a high dosage, should be effective in treating and preventing thrombi, though high doses of that order were more likely than lower doses to cause excessive bleeding. The question would be whether the data provided sufficient support for a once daily dose that would have, for a lower once daily dose that would have a sufficiently sustained antithrombotic effect over 24 hours. So he seems to be back to the same question, essentially, that he's been asking from the beginning. And then just says in 256, in my judgment, the overall views taken by Hirsch and Wilkins were the more realistic. The data gave reasonable grounds for the belief that a once daily dose of 30 would be likely to have a sustained effect over 24 hours. It doesn't actually say there therapeutic. The data as a whole offered no reason to believe that would cause excessive bleeding. Neither the possibility of excessive bleeding or sufficient efficacy could be completely ruled out with such a regimen, but as I've discussed, some risk was inevitable. So he seems therefore to be making the finding, and then in 257 he says, I think the combined evidence of Hirsch and Wilkins was correct, taking the position conducting a phase 2 trial would not have caused an acceptable level of risk. We say, ultimately, that conclusion is based on no reasoning, simply that Professors Hirsch and Wilkins were being more realistic. But we don't really get anything as to why he thinks that that is the case. And in many ways, it's a remarkable finding to make without acknowledging his pre-existing findings on 165 to 167 as to the basis on which Professor Hirsch had approached his views on the likely safety and efficacy of a once daily dose, which of course was the parallels with LMWH, heparin, and other factor Xa inhibitors, which the judge finds not to be part of the common general knowledge. See also 227, in the middle of that paragraph, where he's summarising the cross-examination and refers to Professor Hirsch, even at that point, it's about 12 lines down. Professor Hirsch made his point about the predictive value of heparin and LMWH, and as I've found, this carries no real weight. So he appears to be simply adopting Professors Hirsch and Wilkins. I'm concentrating on Hirsch because he's the clinician, and as the judge found at paragraph 61, ultimately the clinician is taking the decision on dosing. It's odd that he could simply prefer Hirsch and Wilkins over the other witnesses without acknowledging that these witnesses, at least Professor Hirsch, who's the key witness, was wrongly instructing himself in giving his opinion and didn't reflect the approach of the ordinary skilled person. And it's ironic that he's, in that respect, rejected the claimants, the appellant's witnesses as too gloomy and determined to be negative, which is 247. Well, at least they were starting from the same position of ignorance as the ordinary person.
Yes, but their evidence was you wouldn't do a phase 2 trial at all, which even your clients didn't feel able to support in closing submissions.
Yes, well, yes. To be fair, that was their primary view and legitimately reached, as far as they were concerned. The judge doesn't denigrate them for doing so. But Professor Crowther also said, well, if I was going to do it, given the inadequacy of this data, I'd definitely go for twice daily for all the reasons that we've already discussed. Sorry, my bad. So what I need to turn now to is what we say are the errors of principle which undermine a decision which ultimately seems to have been reached with very little explanation as to why one conclusion as to therapeutic effectiveness or likely therapeutic effectiveness is correct, or one witness who thinks it is correct over another who thinks it isn't. And the first error, we say, is the judge's prejudgment of the case and his consideration that what was really going on here was simply having enough to satisfy an ethics committee. And we say this was a major error of principle in analysis of the whole case.
Well, the whole concept of ethics was actually introduced by the appellant's counsel in cross-examination.
I haven't got in my head the precise order in which, but I think when we look at the judgment, you'll see that it's a point that occurred to the judge himself when reading into the case. At least that's how he expresses it. It certainly is.
Yes, that's what he says.
Yeah,
Undoubtedly.
I don't dispute what my learned friend says about the point having been made in cross-examination, but whether the judge had already mentioned it, I'm afraid I can't say, having not been there. People who
But
were
if it
might
was
be
an
able to-
irrelevant point, why was it cross-examined on?
Well, we'll come to what I say about its relevance, perhaps, and then we can take it further. We say it went rather beyond mere consideration of some relevance of ethics. The judge put the whole thing as if it was simply an ethical case, and that's all one had to think about. And one sees that in the judge's account of what his heading headed success that starts at paragraph 119. And I've shown you some of this already, the distinction between phase 1 and phase 2 trials in 119, 120, 121 and 122, the need for caution and why. But then at 123, the judge gets on to a statement about what happened during his reading for the trial. And he says, during my reading for the trial, it occurred to me one of the unusual features of the case was the basis on which an inventive step was apparently being claimed. The usual rationale between the patentee's argument in favour of an inventive step based on the skilled person with no reasonable expectation of success is that the skilled person laboured under a conventional technical perception or prejudice regarding the relevant subject matter. In consequence of this perception, the skilled person who had no reasonable expectation that the technical step would succeed, inventor being inventive, rejected the conventional prejudice, saw there was in fact a reasonable expectation of success, and made the invention. I mean, it may not matter. We say, of course, that's one way of arguing a case of obviousness, but it is far from the only one on reasonable expectation of success. It may well be the case the inventor isn't an iconoclast. For example, he may simply have acquired information which has led him to the invention, either by happening to have investigated an area that nobody looked at before, or accidentally in the course of looking at something else. So he's got material which is not available to the average skilled person. There doesn't have to have been a prejudice which the inventor has overcome or ignored, but it may not particularly matter. But what we get to is paragraph 124, where the judge simply announces that in the present case there would have been no such perceived technical barrier to the claimed invention on the part of the skilled team. And he then explains what he means by that. The team would have known that it could conduct a phase 2 trial using a wide range of once daily doses, and one small enough to be sure there's no excessive bleeding, up to a dose large enough to be sure of an antithrombotic effect over 24 hours. That may be right, although I'm not sure it was established on the evidence it necessarily would be. But the next sentence is key. He says such a range, that is to say, the range of doses once daily, would have been likely to find the therapeutic window somewhere in the lucky patients administered with one of the doses fitting the window. And that definitely was not part of the evidence before him. And indeed, highly likely we would submit not to be the case in many cases. We've looked at the evidence already as to the ribbon and the therapeutic window. And the idea that there's bound to be a dosage which somehow magically hits the sweet spot, even though you're only applying it once daily, between subtherapeutic, maintaining a level of protection which is therapeutic throughout the period, whilst not straying over the top of the window and causing excessive bleeding. It certainly was nowhere in the evidence that that did exist, or would have been likely to exist, and the skilled team would have known that. And that, we say, is a fairly fundamental error, because what it does is immediately narrow down the invention from the actual technical contribution, which is revealing that it's possible to apply Rivaroxaban at all in a once daily dosage whilst remaining within the window, to a much more limited technical contribution, which is simply finding the one that works, knowing from the beginning that there was one that was going to work. And that wasn't the effect of any evidence of any of the experts. And it's the judge takes that further.
Can you help me on that?
Yes.
Where in the patent does it say that the technical contribution is the finding that you can effectively and safely dose Rivaroxaban at all? What's said to be surprising is that you can administer it as safely and effectively at once daily as you can twice daily.
Yes.
So where does it say it's surprising you can find a sufficiently efficacious and safe dose at all, at any dosing frequency?
That's not how it expresses itself in the patent. That's true. But on the evidence, that was the dispute between the parties.
Really?
We've seen.
So where was your client's expert's evidence? The evidence that it was surprising that you could find any therapeutic window for Rivaroxaban at all?
Well, that was the thrust, of course, of Professor Meyerbohm's ribbon and therapeutic window drawing. The whole point is...
Really? Surely the point of that evidence was that you would, as he explained to the judge, that you would expect to have to dose more frequently at lower doses. And that's why that was why he thought you should dose twice daily.
Yes, but the point of the ribbon is that you need to retain as narrow a ribbon as possible to ensure that you are within the therapeutic window. So low dosages frequently applied, as the judge is finding at 176. And it is therefore, from the perspective of the patentee's experts, inherently surprising, given the prior art, where we have the short half-lives, that you can find a single dose that works.
At any frequency of administration?
Once daily. Once daily. Yeah. Whatever level that is, because, of course, yes, of course, you could jack it up to a very high level, try and maintain the utility over 24 hours. But at that point, you're straying way above the therapeutic window, potentially.
Okay.
And we say what the judge does, paragraph 128. Well, the judge, 126 to 127, He says one might first suppose Bayer's case is that although the skilled team wouldn't have taken any inventive step for ethical reasons, prepared to put patients' lives at risk. That can't be right, because clinical trials may be performed only if approved by external ethics committee, or an ethics committee who must have approved the proposal, so it's presumed that lives were not unacceptably put at risk. Well, yes. But then in 128, he follows through on his earlier finding. We say, presumably, where there's a reasonable expectation of technical success, patients are at risk of harm, there is no reasonable expectation of success within the meaning given to that criterion. Neither side of the trial put its case in exactly that way. I think it's to be inferred. And then he turns to the ethical question. So he started with this reasonable expectation of technical success as a premise, and that, we say, is what he's found in 124.
Well, can I ask the same question a different way?
Yeah.
Do you dispute, given the way your client's case was put in closing at trial, that the skilled team would have had a reasonable expectation of success with twice daily dosing at 30 milligrams?
Yeah. No, that's correct.
Right. So they had a reasonable expectation that there was a therapeutic window which was safe and effective.
For twice daily administration.
Right.
To be hit
So what the question comes back to what you were submitting about the technical contribution was whether there was also a reasonable expectation of success once daily dosing, given the premise that there was an expectation of success for doing it twice daily.
Yes. And we say, because twice daily inherently gives you that extra value of topping up when you're concerned about a short half-life and ensuring you're not drifting into the subtherapeutic region in the second 12-hour period. Inherently, of course, it may be obvious to do it twice, but far from obvious that doing it once would be likely to succeed.
Yeah.
That's our proposition.
Understood.
And we say the judge essentially prejudges that by his finding in 124, because he's already found that once daily is going to work. And we say there was no basis for that. But having found that some point once daily is going to work, the judge's premise is, well, all you're doing, you're going to the ethics committee and you've got a range of dosages that you're going to give once a day, one of which you know is going to work, and is the ethics committee going to be prepared to accept that as a trial? And that really is what he says in 129 as being the question. And we say that is the question that then fed through to all of his analysis on obviousness when looking at the evidence in the case. It caused all sorts of difficulties for the judge, as you can see at 240 to 242, because of course he didn't have any evidence about ethics committees or the kind of approach they would take, or whether they would be tough or easy. And he ends up between 242 and 244 turning to try and draw some conclusions from what he did know to consider what that might tell him about an ethics committee. So that's essentially what he's saying in 242, and he follows through with that in 243. 243 basically says, well, if you're highly risk averse, you'd never do phase 2 trials at all. But of course that prejudges what information you might possibly have before you embark on them. In this case, phase 1, Arnold and Kabit.
Well, you're not submitting, are you, that phase 2 trials are entirely risk-free?
No, absolutely. But the problem was nobody in the case...
So if you were highly risk-averse, you wouldn't do it. And yet it's done all the time.
They are done based on some on the evidence, unknown test that the ethics committee presumably apply to assess, presumably bearing in
So
mind
the submission comes to this. In the real world, what the judge says is correct, but you say it's legally irrelevant.
Yes, and we say it caused difficulties because he couldn't actually find what level of scepticism or risk profile would be adopted in this particular case. I mean, what he ends up going in 244 into examples of other trials with other drugs causing some deaths and yet being allowed to go ahead, and they must have received approval in the first place. I mean, how that works in the present case, it's unclear whether it makes the ethics committee less willing to approve because of the experience of previous trials, or indicates that they are more gung-ho because they were happy to allow that one to go ahead. Who knows? I mean, we say all this is just effectively worthless speculation to which the judge has been led by looking at the case from the wrong direction. We say the question is a technical one, it's not an ethical one. The question is whether it would be obvious to the skilled team that there would be a reasonable prospect that the dosage regime would be safe and effective, not whether they think that they get approval to carry out a range of regimes from a watchdog, particularly knowing, contrary to the evidence in advance, that something would work. And we say that his whole analysis of the evidence at 245 to 257 can be seen to be undermined by that error, because at 245, having considered all that stuff again, he says, with that in mind, I turn to the question. So he is plainly addressing the evidence based on what we say was a fundamental error to start with. He's really just consulting the prior art to see, knowing that something is going to work, whether he's got enough in Harder and Kabit to persuade an ethics committee to give its permission for a range of trials. Can I move on to the second point? Because time is moving on, which is the Bayer invention story. I put that in inverted commas. And we say it's a related point because the ethics committee point seems to have led the judge to focus on the lack of evidence from Bayer themselves as to how the invention came to be made, and we say that's another error of principle. And in a nutshell, the judge's reasoning on this seems to be the prior art is the phase 1 trials. We know Bayer went ahead with phase 2 trials, including a once daily dosage. Relevant ethics committee must have approved those trials. I've found as a judge that the relevant test for obviousness is whether the ethics committee would approve phase 2 trials. And I haven't been told the ethics committee were given any other information than that which appeared in the phase 1 trials, therefore the invention was obvious. And that essentially is his reasoning at 124 to 129. And he comes back to that at 259 to 260. Where essentially that is his reasoning. He essentially puts the burden on Bayer to advance a reason why they had thought of something which the uninventive skilled team would not have thought of. And that's the last sentence of 259. And when it's pointed out by Bayer's counsel that there could have been more data before the ethics committee than what's been reported in Harder and Kabit, he says, oh, well, it doesn't follow that that would have been materially different. And then he says it would be odd if there was something and Bayer had chosen, presumably in the evidence in this case, not to mention it. In other words, he's starting with a presumption, we say, that Bayer simply used the Harder and Kabitzer posters with no other research or special knowledge to decide to include a once daily dosage phase 2 trial, and simply effectively showed those posters to the relevant committee. And because Bayer hadn't advanced some special story in which they said, no, there was more evidence, we had some other trials, we showed all this to the committee, there was essentially a presumption of obviousness. We say that approach is wrong in law, it's riddled with logical and factual errors. As we said, the Ethics Committee is not the touchstone of inventiveness. Secondly, it's trite law that the thought process of the inventor is not relevant to the question of obviousness. It's certainly not the case that the inventor needs to have shown an invention story to demonstrate that he's not the uninventive skilled person, and thus to avoid the argument, well, if you thought of it, it must be obvious. The question is just an objective one. Would the invention have been obvious? The uninventive person. 99% of patent cases proceed without any evidence from the inventor at all. In many cases, of course, you don't have access to the inventor to give the evidence in the first place, and it would be unworkable to proceed in this way. It leads to arid debates about whether the inventor was inventive or not. And thirdly, no basis for believing that either the inventor or the Ethics Committee only had the data in Kabit and Harder. One might think the opposite, in fact. These are summaries of research. They don't purport to include everything. Nor do we know what other internal studies may have been done before the once-daily dosage trial was actually put forward. Fourthly, no reason for believing that Bayer had the same background knowledge as every uninventive skilled person. We know, for example, Professor Hirsch had special knowledge. Bayer may have had that or more and used that or more to put before the National Committee. This passage, of course, is strange in that it ultimately reaches no conclusion, but we submit it was plainly part of the judge's overall assessment and clearly affected his view on obviousness. Otherwise, why mention it at all? And it also needs to be read, although probably no time available, with the long account of the invention story run in other jurisdictions that he sets out, and you have read it in the judgment between 133 and 158.
We have read it carefully.
Yeah. We say the sentence at the beginning of 259 doesn't hermetically seal the analysis that he's already undergone from the invention story part of the judgment. He plainly was taking it into account, and we say that's wrong in principle. And finally, can I turn to the third error on which we rely, which is the point relating to the authors of Harder. It will be clear that a lot turned in this case on the significance of the fourth bullet point in Harder, which was the only suggestion in the documents of once daily dosage. One might think the words suggests suitability are on their face not particularly striking or encouraging, and yet, as the judge finds in 249, he says they would have been regarded as striking and encouraging. And it's quite plain that the reason he thinks that is at least strongly, in part, based on the identity of the authors. And the second sentence of 249 sets that out at a high level. The first point he says is that the authors were either, like Dr. Harder himself, distinguished clinicians of apparently international renown, or, like Dr. Misselvis, senior figures in Bayer, very much a leader in the field. And then goes on to say the skilled team would, in my view, have considered carefully why these authors have been prepared to put their names to that statement. So it's not merely a question of, well, these are authors of a scientific paper. It's that these are authors of unusual eminence and therefore deserve greater consideration and can't simply dismiss the conclusion on the basis that the data wasn't really supportive of it, because why otherwise would these eminent people have come to this view?
So this is an attack on a primary finding of fact, and therefore you have to demonstrate that it's rationally insupportable. I take it you accept that?
Yes, we say it's just not in accordance with the evidence. Quite plainly not.
Right, so let's take just one author,
Yeah.
Professor Brazin, who, interestingly, was not a co-author of Kabit, either of them.
No.
So he lends his name to Harder, and is identified by Professor Hirsch as an academic clinician who was very well known internationally, and Dr. Misselwitz gave evidence that he was both a founding director of the International Institute of Thrombosis and Vascular Diseases and director of the Division of Angiology at Frankfurt University. Are you disputing that he's a person of eminence?
No.
Right. So you have one scientist who is a person of evidence who puts his name to the paper. Why is that not sufficient on its own?
Right. Well, the judge's finding in that sentence, first of all, relates to the authors of Harder generally, apparently all of them. Either like Dr. Harder himself, who of course is the first named author, one might think therefore the person primarily responsible for the content. They were either like Harder himself, distinguished clinicians, plural, of apparently international renown, or like Dr. Misselwitz, senior figures in Bayer, very much leader of the field. We say there are at least 3 points being made here. One is Bayer, and the fact that most of these authors came from Bayer was significant because it was very much a leader of the field, as we've made clear in our skeleton and the references we've given. They were not known in this particular field at that date. Now, clearly they were a well-known pharmaceutical company, but not in the treatment of thromboembolic disorders. So that's simply wrong on the facts, we say. Dr. Misselwitz may have been a senior figure in Bayer, but there was no evidence. The real question was, would the skilled person know that? And there was literally no evidence that they would. So that statement is wrong. Dr. Harder, as we've said, there was no evidence that he was known at all. He was plainly a researcher at the University of Frankfurt. All that remained was one clinician of international renown, who was Professor Bredin, who was the last named author on the Harder paper. He also is from the University of Frankfurt, presumably the head of Harder's department of the Institute of Pharmacology at the University Hospital, University of Frankfurt. So those propositions we submit are simply not correct, and the fact that there is an author who's a clinician of international renown doesn't save the overall proposition. The judge had said one of these authors is Professor Bredin, who we agree was a clinician of international renown. He would then have had to say, well, what can I conclude from that? And that does raise a rather broader point, because it can't be taken as read, we submit, that the mere fact that one of the authors is of international renown makes statements in a document somehow more compelling if they don't actually appear to match the data in the document.
Well, there's two points there. I mean, of course, as you say, at the end of the day, the data is the data and it's the data that matters. But are you suggesting that a statement that's made by a scientist of international renown has the same weight as a statement by a scientist that nobody's ever heard of?
We say that may well be the case. It would depend on the evidence. I mean, just taken at a broad level, one could imagine a case where the evidence was, well, I can see Professor so-and-so, who's very well known, has put his name to this paper. But frankly, he's known to have signed off on 2,000 papers last year as the head of the department. He can't conceivably have read them all in great detail and be held responsible for their contents. His name. Did
you lead any evidence to that effect about Professor Bredin?
No evidence was led either way on that fact or the contrary fact. I'm going to show you.
Sorry. You had a witness who testified to his position, and the claimants had a witness who testified to his eminence.
Yes,
so
but the
if
point
you
I'm
wanted
making
to
is
say
different
that his evidence, his signature on the paper was valueless because he was well known for putting his name to thousands of papers, didn't you need to lead some evidence?
No, the point I'm making is a much more general one, that the proposition must be, on the facts of this case, would the authors of this paper make people think differently about the data that's been disclosed in the claims that are made than they would otherwise. And if that's the case, in what way would they think otherwise? As a thought experiment, I gave the example that you might, in fact, in one particular case, think the opposite. And the mere fact that he was well known is neither here nor there. Maybe other cases where you say, yes, I know this fellow. He always reads papers with incredible care, and he never makes statements which are not justified by the data, and I place particular reliance on what he says. But we didn't have that. We didn't have any of those statements in relation to the conclusory statements that were made in the document. There were some statements in the evidence which dealt with the nature of the authors of the paper. And one can see that from the annex to our skeleton, where we've set out all the evidence references.
Well, except they're incomplete, as the respondents have pointed out, because there are some more. But yes, we've read all of that.
We've done our best. It may be that there's more there. But essentially it said, well, I think there is evidence that you could expect the assays to have been carried out properly, because they're carried out at a reasonably reputable institution. That's Institute of Pharmacology at a university hospital of a university in Germany. But there was nothing to say that the presence of Professor Bredin on the document was in some way a major factor in concluding that the conclusory statement in the bullet point was more reliable. And indeed, Professor Crowther gave the opposite evidence. He said, no, I'd always go back and look at the data. I wouldn't be particularly interested in exactly whose name was on it. And of course, it's not just Professor Bredin. The judge is relying on the buyer seniority and the buyer experience, and that clearly is wrong on any view. So we say, however you look at these findings, the factual basis for them is wrong, and the judge is therefore relying on matters that he shouldn't have relied on, and that does undermine his judgment. Yes, one can say, well, at least there was one eminent author the judge didn't mention, but the judge has got all the facts we submit here incorrect, and he's plainly placed far too much reliance on all the authors being authors of eminence, which was kind of the way it was put in cross-examination. And if you follow the cross-examination through, you'll see how the eminence of these authors seemed to increase every time a question was put. But the facts were never properly established at all. And we say an inflated respect for the authors of the document was foundational to the judge's attitude to the key statement in the fourth bullet point, and how far you would dig into the data and how much credence you would give to it as establishing that such a statement could fairly be made. We say in the end, wrap up now, what did the judge have ultimately to reach the conclusion that he did, preferring Professor Hirsch to the claimants, to the defendant's witnesses? I mean, particularly when Professor Hirsch had not based himself on a correct approach to the cross-examination, to the common general knowledge. We say the judge was clearly placing in the scale against that the suggestion that the authors of Harder themselves had an unusual eminence and had a special influence on the skilled reader. That was a stepladder being used to elevate the suggestion in the bullet point into more than the sum of the data which was actually presented to support it. And if a stepladder is kicked away, we submit, as it must be, because these facts were simply wrong, there is nothing left or at least nothing like enough that would have supported a finding of obviousness in this case. We therefore say that error as well undermines the reasoning of the judge and his finding of invalidity. Ladies and brothers, I'm conscious of the time and I've overrun, but unless I can help you further, you have asked.
Thank you very much indeed. Mr. Copeland, Ms. Hart, do you follow? Thank you. Mr. Speck.
My ladies, my lord, ultimately there's just one point that matters in this case. And it's this. Having heard a very significant body of evidence from clinical and pharmacology experts from both sides, the judge preferred the evidence of the claimants' experts as to what dosage regimes would have been obvious to take forward into routine phase 2 tests. That is, if one went forward at all with any dosage regimes, which ultimately Bayer had to accept one would, contrary to the first line of defence in its expert evidence. That, in my submission, is the central point that matters in this case. Ultimately, it's a finding of fact based upon a large body of evidence, and more specifically, the judge accepted the claimant's expert evidence put forward by them, both of them independently, before either of them had seen the patent, that a 30 milligram once a day dosing arm would be included. They both thought of that when they looked at the material, and they would have taken that thought into the meeting between clinician and pharmacologists in the real world if a project was going forward. And simply doing that is enough to hit the claim. And for my friend to succeed, he has to show that he can disturb that factual conclusion. And ultimately, that's what he's tried to do today, is to basically re-argue the case and then spend 20 minutes at the end trying to say how the grounds of appeal that he's got permission for fit it. The submissions were very much focused on just trying to re-argue the case. We say it's a conclusion the judge was perfectly entitled to make. And indeed, when one digs into the rival contentions and their underlying evidence, my ladies and my lord will understand precisely why he came to that view. And of course, what the judge accepted was that the ordinary skilled team, looking at the results of Bayer's own phase 1 work, would see the data presented across all 3 posters and Bayer's own express conclusion that Rivaroxaban was suitable for once daily dosing, and they would share that view as to the suitability of once daily dosing. But, my ladies and my lord, please note it's much more than looking at that one express statement, the 4th bullet point, and simply following it. The claimant's experts explained what they saw in the underlying data and why they agreed with the statement made by Bayer and the colleagues working from Bayer, who were the authors of Harder, including Professor Bredin. And importantly, they both identified the same specific once-a-day dosing regimen they believed the skilled clinician and pharmacologist, respectively, would wish to include. Why am I labouring this point? I've mentioned it twice already. It's because it illustrates that it's much more than simply following that statement. The statement in the conclusion in Harder is not specific about the dose or the doses that might be selected. It simply refers to once-a-day dosing as something that Rivaroxaban appears to be suitable for. It's the consideration of the body of data that enabled Professors Hirsch and Wilkins to separately identify that same thing, 30 milligrams once a day. as one of the dosing regimens that the skilled clinician and pharmacologist respectively would identify to take forward into phase 2. And as I should explain, they did that looking at the crucial pharmacodynamic or PD data that was presented in those posters, together with the information that was then available as to half-life, which is known as PK, or pharmacokinetic data, as my learned friend has explained. Now, in the minute or so before the shorter German, can I just tell you how I intend to structure my submissions? Because that was just the headline explanation of the point that really matters.
What, the one you really want to make before we all break?
That's right. The one that I want to stick in my lady's mind. And actually, all joking aside, the case really is that simple in my submission, but I'm obviously going to deal with the rest of the arguments that my friend put forward. Firstly, what I'm going to do is outline the key aspects of common general knowledge. My friend's obviously touched on that quite a bit, and I'm going to try and take it quickly, but there's obviously different nuances that I want to bring out, and I'm going to try to take the bits that he's dealt with quickly, more quickly, but I obviously didn't know what he was going to say when I did my notes, so I'm going to do it as quickly as I can. Then I'm going to identify the key battlegrounds and contentions that were before the judge, because it's really important to understand what the arguments were as to why he said some of the things that he was saying, why he was looking at particular issues. And in doing both of those two, I intend to flag up the key findings the judge made that provide important context for the argument that my friend now advances to attack the judge's finding of obviousness. And then I intend to move to address the alleged errors that he identified in the skeleton. And that wasn't structured in quite the same way as in the grounds of appeal. And my note is structured to follow his skeleton, where he identified 4 alleged errors. I will check with him, because one, he did not press orally, the second one, the wrong standard of efficacy. It may have been a timing point, and if he's still maintained, even though he hasn't addressed it orally, I'll deal with it. But he only actually pressed 3 of the 4 in his skeleton, and I'm going to find out whether I have to deal with all 4 or just 3.
So that'd be convenient, would it?
It's
Right. Thank you very much indeed. 2 o'clock.
All right.
Sorry.
Very loud language in the garden the other day. I was out playing with my little son. Sounded, the message all went round.